And we're back with Law 1204, and this is our part 2 video lecture on special liabilities, and we're focusing on for the next few minutes here on vicarious liability. So what is vicarious liability? It essentially finds somebody at fault and holds them liable for something that they haven't done themselves. It makes somebody legally responsible for the acts that somebody else does. This is also known as an agency relationship. You might not have taken employment law yet. In fact, I believe you don't for a couple more years still. But employment law, that course will talk to you a little bit about the agency relationship in the area of the employee and the employer. And we're going to talk about that very briefly. So I'll give you an introduction to it. Agency is known as the Latin term respondent superior. It essentially just means there is a relationship with a principal and an agent. A person is a principal if they are if they have somebody else acting on their behalf. Okay? A principal gives agents duties to carry out certain tasks, and they do so. If they're doing this and they commit a tortious act while doing so, it makes the agent, the principal, or the employer, perhaps, liable through the principle of vicarious liability. Okay. So, let's talk about the employer-employee relationship here. So we have the principal and the agent. The employer would be the principal. The employee would be the agent. And typically, the vicarious liability principle suggests that the employer is found responsible for the acts of the employee while the employee is acting in the context of their duties. So this doesn't mean when they're out on the weekend doing something completely non-related to work, but while they're acting within the course of their duties as an employee, the employer would be held liable for any tortious act that was committed. This is a good thing, right? Because employees probably don't have the resources. They don't have the money to pay out for any harm, perhaps, that they've caused to a client or customer of the organization for which they're acting. But also, the employer should be held liable because they're the ones benefiting from the activity that the employee is engaged in, right? If the employee is out there interacting with customers and clients and getting business on behalf of the organization, the employer is benefiting from that. So therefore, they're also going to be held liable for whatever occurs in the course of that relationship or, I guess, customer building, right? There might be an apportionment of costs. So we've talked a little bit about jointly and severally liable, where the court finds two defendants and apportions costs accordingly. And this could be a situation where the court says, okay, employee, you're going to be responsible for 20%, employer is responsible for 80% of damages, or something along those lines, okay? Two cases to point out to you. The Romford case, which is mentioned on the slides, talks specifically about employers who may be able to seek indemnification from employees. What does that mean? Essentially, if an employer is found liable in a vicarious liability case for something that the employee has done, indemnification means that thereafter the employer can sue the employee to get that money back, recover that money. It's the Romford case that stands for that. It's a House of Lords decision out of the United Kingdom. Canadian law has turned a little bit away from that perspective of indemnification, so employers going after employees, because they think it basically pares down, I should say Canadian lawmakers think, the courts think, it hampers that relationship, that agency, that concept of vicarious liability in tort law that we have taken so long to build up, right? To bring protection to employees. So Canadian lawmakers don't really like that idea of employers being able to get indemnification from the employee. Some questions that come up in this area of the law then is this individual acting as an employee or are they not? And of course, an employer organization is going to want to argue that they were not. They were not acting in the course of an employment when this claim arose, because if the court finds that they were, then the employer is going to be held liable for those damages, right? So the employer is going to want to try to argue that, hang on a second, the employee was not doing anything in the employment context when this happened. And a couple ways they could go about that is one, saying they were just completely acting outside of their duties. They weren't on a scheduled shift at the time. They were doing something in their own personal time. So that one might be a little bit more obvious to prove. Another way they could go about it is saying, hold on a second, they're not an employee, they're a contractor. And if they're a contractor, then I'm not their employer, and that agency relationship doesn't exist, and therefore vicarious liability should not extend to me. So the courts have used something called a control test to determine if, in fact, somebody is an employee versus a contractor, and to what extent they are an employee, and therefore is the employer liable through vicarious liability for the act. The control test says if the employer tells the employee what to do and how to do it, then that activity is primarily characterized as being in the control of the employer, and therefore that individual is an employee. So if the employer is telling the employee what to do and how to do it, they probably are an employee, not just a contractor. There is the Sagaz case, which is also referenced on the slides for you, says, is that control test enough? And maybe it's not. The Sagaz case says the control test is important, but there are other factors as well in determining the employee-employer relationship. For example, did the worker provide their own equipment, or did the employer or the organization provide it to the employee to complete their jobs with? Could they hire and fire those beneath them? Did they manage and direct work? Did they retain any profits for themselves? All of these questions go to the heart of distinguishing between an employee versus a contractor. So there's a number of Canadian cases that discuss those distinctions. There's not necessarily a clear answer. It's more of a continuum along the line of employee versus contractor, and where on that continuum does the employee fall, and then where on that continuum, based on where on that continuum do they fall, is the employer going to be held liable for whatever act was committed during the time of their employment, okay? A basic question that the courts might, ask themselves in trying to determine if the employer or organization should be held liable is looking at the act itself, okay? So is the act so unconnected to the employment that it would be wrong to find the employer liable? So you can see it's a very narrow window in which we're trying to limit liability to the employer. In more cases than not, the employer would be found liable. And that's again because of the benefit that they receive from employees acting in their interests, right? Pretty much financial interests for the organization. Okay, we're going to wrap that one up there then. So thanks for listening to this short discussion on vicarious liability, and tune back in for part 3 where we're going to be talking about damages.